bench of the High Court is set to determine whether Queen's Counsel Howard Qureshi will prosecute the case against Deputy Chief Justice Philomena Mwilu.
The ruling, which has been set for the 24th of January, will also see the judges give a determination of an application filed by the prosecution seeking to bar lawyers James Orengo and Authoritative Omogeni from Mwilu's defense team, citing conflict of interest.
It was a battle of wits as the prosecution and defense teams in the case against Deputy Chief Justice Philomena Mwilu made submissions over two crucial applications that will largely determine how this case will shape up going forward. The applications, one filed by the prosecution seeking lawyers James Orengo and Authoritative Omogeni to recuse themselves from representing the DCJ for conflict of interest by virtue of them sitting in the Senate Legal Committee, and another by DCJ Mwilu challenging the appointment of Queen's Counsel Howard Qureshi to represent the Director of Public Prosecutions in the case. This lays ground for the commencement of the case against the second highest judge in the land. In his submissions, defense lawyer Senior Counsel James Orengo told the court that the Director of Public Prosecutions, Nordin Haji, exercised powers that he did not have in appointing the Queen's Counsel to prosecute the case.
So there are 2 points we're dealing with. In regard to the Gazette notice, to the extent that it was appointing him to act in a case which is not a criminal case, that fell out within the ambit of his powers under the Constitution and under the Criminal Procedure Code. Secondly, he could not appoint a private practitioner under Section 85 of the Criminal Procedure Code, subsection 1.
For the prosecution, Deputy Director of Public Prosecutions Dorcas Odwor sought to dismantle the defense argument.
Those submissions make it absolutely clear that the petitioner's approach can only be sustained by doing violence to the Constitution and the legal framework in a multiple of ways. Firstly, with reference to the constitutional role of the DPP, the powers conferred upon the DPP, and the practical exercise of those powers.
Senior Counsel James Orengo also raised questions on the procurement of professional services by the DPP, citing that the law was not followed, claims dismissed by State Counsel Alexander Muteti as having no legal basis whatsoever.
If you look at the guidelines, first of all, the Director of Public Prosecution is not telling us which is the method that he preferred to use under the Act, because the Act sets out different methods for procurement.
The party complaining about the decision of the procuring entity has not even been specified. Why do I say so, my ladies and my lords? The application filed seeking the disqualification of Professor Howard Qureshi, the affidavit in support is by Nelson Avi. Is Nelson Avi the complainant?
In the second application seeking to throw out lawyers James Orengo and Authoritative Omogeni from the defense team, lawyer Nelson Harvey, appearing for the DCJ, argued that claims by the DPP that there was conflict of interest held no water.
There is no evidence whatsoever of any question that was asked of the DPP by Senators James Orengo and Eric Authoritative Omogeni. On the basis of those facts alone, this application must fail.
In my humble submission, the petitioner has completely misunderstood the issue we are raising. We do not take issue with the fact that Honorable Senior Counsel cannot appear in court simply because they are senators. Our argument is, when they sit as senators and receive information during committee proceedings, then they cannot use that information to advance the interests of their client.
The fate of Queen's Counsel Kawar Qureshi now lies with a 5-judge bench comprising of Justices Helen Omondi, Mumbing Ngugi, William Musyoka, Francis Tuiot and Chacha Mwita, who are set to make the ruling on the 24th of January. The ruling on the prosecution's application against lawyers Orengo and Okongo Mugeni is also expected to change the dynamics of the case for the DCJ Philomena Mwilu. DPP Haji is seeking to have DCJ Mwilu charged with abuse of office and improperly using her office to obtain the execution of 12 million Kenya shillings security belonging to the collapsed Imperial Bank between August and October 2013. Akisa Wandera, KTN News.
Affiliate parties in the opposition, NAS